Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel and Elizabeth. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
Trade secrets are essential in the tech space, including for semiconductor companies. Not surprisingly, a huge percentage of semiconductor intellectual property is in the form of trade secrets. We recently discussed on another episode the importance of protecting all of your company's ideas. And listeners will know that not all ideas are suitable to file as a patent application. It's sometimes better to keep things as a secret. It's easy to say that something will be confidential going forward, but how do you implement a strong policy for this? It can't just be the lawyers, so what's HR's role? And what's the impact to partners or a potential buyer for a company if you don't have one? We're joined by my colleague, Luisa Bostick, to discuss developing a strong trade secret policy and working with your leadership team on how to implement one. Luisa, to start us off today, would you mind giving a quick introduction to yourself?
Of course. Thank you very much for having me today. As Nathaniel mentioned, my name is Luisa Bostick, and I am an attorney at Hodgson Russ. I specifically specialize in labor and employment law for employers based in the United States, as well as those in Canada and Europe. And I really handle any employee-related issue from policies and procedures to hiring to firing and everything in between.
Luisa, thanks so much for being on this show with us. Back in my Morgan Lewis days, I worked with a lot of labor and employment attorneys, so we should talk later about all the fun stories that come out of that. But for today, I know we have a lot of listeners that are kind of smaller startup type companies. Can you just high level tell us, what are the bare minimums that an employer needs to do to protect their trade secrets?
I would say at a bare minimum, employers should have a policy in their employee handbook that defines confidential information and goes through what specifically the employer is intending to protect, what it defines as confidential information, any particular IP concerns that it has, and outline those as well, and to ensure employees understand what the company considers confidential, what is the property of the company, and what would happen if the employee potentially released some of that confidential information. If the employer only has that in their employee handbook, they need to ensure that employees sign off on that employee handbook. Even a better practice is to have a separate and distinct confidential and IP policy that employees would specifically sign off on, outlining those same exact things. How does the employer define confidential information? What exceptions are there to those confidential information? Because those exceptions are key to ensuring compliance with both federal and state law. And what are the employer's rights to IP that's developed during the course of employment?
Just one quick question on that. When is the right time for people to look at that? Is that something that the employer should be trying to do kind of really at the onboarding process level, or does it need to be done every year? What's the kind of time and does it ever need a refresh?
It definitely should be done during onboarding, because as soon as an employee is onboarded, they likely are having access to your confidential information. And although you'll probably have a provision in your confidentiality agreement that says this applies no matter when you receive the confidential information, it's really best to have that in place at the start of employment so the employee knows exactly what your policies and procedures are and can ensure compliance with them going forward. If you have an employee who is kind of right in the center of your IP and is constantly creating new IP, it might be a good idea to have a refresher. For an employee who's not really in the heart of that, it probably isn't as important. But if it's contained solely in your employee handbook, you are going to want to make sure that employees are reviewing that employee handbook. And if there are updates to that handbook, that they're aware of those updates, whether it's specifically to that provision, the confidentiality policy or not, you're still going to want to make sure employees are aware of those and potentially signing off on being made aware of those updates to the handbook.
Besides getting everyone to sign a confidentiality agreement or a trade secret policy, preferably when they're onboarded, so you don't have to try to do this retroactively, which is imperfect at best. What else needs to be done? Is there anything else in terms of education or making people aware that usually is part of this?
Making sure employees have copies of the policies. Don't want to just hand them the sign-off sheet and not have them actually read the policy. As part of signing off on it, they should acknowledge that they've read and understand it. It may also be important for employees who are coming in that are, again, kind of in the center of that IP, that they provide you with a list of any other patents or works that they have done in the past, so that you're kind of protecting what is their work, what is your work. And in relation to that, a provision in your policy that if they incorporate any of their past work into your work, it becomes your work. And you then have rights to that work and can use it at your free will. So making sure that employees are not only reviewing your policy, but signing off on it and making it accessible to employees, whether that's on your intranet or wherever you keep your policies and procedures, just making sure employees have access to that. So if they ever have questions going forward, they can refer back to it.
Following up on that, is there a refresher that employers should look at? Because I know, having been in-house, that occasionally you would have sort of either a webinar or a live presentation to talk about the importance of this with employees, just to keep it at top of mind. Is that something you see employers doing?
I don't see employers doing it as frequently as they probably should have. But if you are the type of business where there really is key confidential information or key IP that you want to ensure remains confidential, and then it's in the forefront of employees' minds that it needs to be confidential, I would definitely recommend doing refreshers on this and reminding employees of what the policy says, what is considered confidential, because employees tend to have a short-term memory, especially from stuff that they're covered during onboarding. They're handed a lot of information on onboarding. They read a lot of policies and they forget half of those policies. And if you have long-term employees, 10 years down the road, they probably forgot that they even signed this document. So yes, I definitely recommend refreshers for your employees as time goes on.
All right. So Luisa, do you have any best practices that, especially the tech sector, as the tech sector for an HR professional should keep in mind? What are things that technology companies seem to struggle with, or what are things that you've seen work really well in that space, or maybe more interestingly, things that don't work?
So, this is going to be an overgeneralization, but a lot of tech companies start off very small. And so in the policies and procedures are not in the forefront of anybody's mind, and they frequently don't have HR staff or a handbook or just general policies and procedures. So I think developing those things are very important. And you may not have an HR person right off the bat, and that's fine. And you may not have a handbook when you hire your first, second, third employee. But as you continue to grow, you need to develop those policies and procedures in that handbook. And making sure everything is organized is probably one of the key things for HR professionals. If you're having employees sign off on a confidentiality and IP policy, but you don't keep that sign off somewhere that's easily found, what value is it? Nobody's going to take the word of your HR professional when they say, oh, I promise he signed it. I don't have a copy of it, but I know he signed it. You need to have that document. So making sure that you're maintaining those records, whether that's electronically or in a physical file, that's really the preference of the company. You don't necessarily have to have a physical personnel file as long as you have those documents in one location that you easily can access if later on down the road there does become a claim regarding your IP or an employee's breach of your confidentiality agreement. You need to be able to show that they had that agreement, they signed it, they understood what they could and couldn't do, and they violated it. And now we're going to take next steps to enforce it and potentially get damages as a result.
You essentially already answered this question, but I just want to ask, what happens if you don't have a policy, or let's say hypothetically, none of the signed copies that your employees actually signed at onboarding can be easily located, such as during due diligence or in preparation for a lawsuit? Not that that would ever happen to any client ever. What goes on if that happens? What's the effect?
If you don't have a policy, there's nothing to enforce. Yes, some states may have duty of loyalty requirements, but not all states do, so you cannot rely on that. And so you may not have any protections for your confidential information. Your employee can leave and go to your competitor and share the recipe for your secret sauce. And you would have there'd be no repercussions for that action if you don't have a policy or you don't have an enforceable policy because you didn't have a copy of it or maintain it. And it leads to one problem after another of not being able to protect not only your confidential information, but also your IP. And your company is, if you're a tech company, it's only as valuable as your IP. And if you can't protect your IP, you lose a lot of your value, to say it nicely.
Some of the things that you're saying remind me of the show with Silicon Valley with the Pied Piper company and how they kind of go from this like tiny incubator to something, much more large scale and the issues that come in place when they start actually having HR people and the drama that goes back and forth with that. And then also I think, especially acquisition, living and working here in Silicon Valley, not the show, but the actual place, companies are often trying to be acquired. How is the absence of trade secret protection policy viewed by a partner or a potential acquisition company?
Yeah, it's definitely going to be looked at, as Nathaniel mentioned, during due diligence. The buyer is going to ask for documents and your policies and procedures. They're going to look, what does your confidentiality policy say? Is it enforceable under state law where your employees are located? And again, that may be different if you have employees located in 30 states or just one state. You're going to have to look at the state-specific laws for that, not just federal law. But so they're going to look at your policy and if employees have signed off on those policies and what exactly those policies protect. And if it doesn't protect the company's IP, the value of your company just significantly decreased. And the buyer may decide they don't want to buy the company at all anymore, or they may still want to buy it, but they're going to buy it at a significantly lower price because what they are buying is your technology. And if that technology isn't protectable, they're really not buying anything.
It'd be a real shame to have that loss simply because you didn't save the signed pieces of paper. But
it would be.
Assuming that the company realizes the error of its ways, it recognizes the danger that it's in, the impact to potential growth, the impact to a potential acquisition. Let's say we have a small mid-sized company. They're on the cusp of maybe getting that first HR professional or just evaluating this. What can you do if you are one of those smaller companies and you want to take this more seriously?
The first step is probably either if you don't have an HR professional already, then you move forward with getting one. If you have one already, start talking to them about drafting these policies. If you have a labor and employment counsel, I'm sure they will be more than happy to help you draft these policies. They're not rocket science drafting them, but they do require a careful legal eye because of the various state law requirements and what you can and cannot include in them. And just the definition of confidential information in and of itself is complicated. You have to decide what is confidential in your business and what's particularly important to you, while also making sure you don't violate employees' rights, for example, under the National Labor Relations Act. You can't include in your definition of confidential information personnel information. Some employers may say that, and they want to say that. They want to protect all this information on their employees and their addresses, but that potentially violates the National Labor Relations Act and is prohibiting employees from discussing the terms and conditions of their employment. It may seem a little counterintuitive, but that has been found to be a violation of the National Labor Relations Act. And so you have to be very careful in your definition of what confidential information. You also have to have very specific carve-outs of what is not considered confidential information. And an obvious example is something that's already public. If it's public knowledge, it's not confidential, but it's still important to point that out in your policy and to have a caveat that it becomes public information, notwithstanding the obligations of the employee. So essentially saying the employee didn't make it public. So really, you need to start crafting that policy. And although this may be midway through employment for some employees, you still can enforce these policies and you can put them in place and have employees sign off. One risk of doing it kind of later on in employment is some of that IP work may not be protectable because you didn't have this policy in place. So there may be some works that the employee can rightfully claim are their own and that they can get a patent on and they may sell to you later on down the road, which isn't the position you want to be in. But it may be a possibility if it's integral to your company and the work that you're doing that you have that technology, but you don't have access to it or the rights to it. Going back to the original question, even though you may not have these policies in place right now, you're an existing company, it's not too late. Start creating the policies, take those steps, contact your labor and employment counsel if you have them. If you don't have labor and employment counsel already, reach out to your primary attorney, and they may be able to refer you to labor and employment counsel. Reach out to one of us and we can refer you to somebody in your area. We may not be the right person depending on where you're located, but we may be able to refer you to somebody who can help you draft these policies and ensure that they're implemented in a way that you're protecting the company's IP to the greatest extent possible.
Okay, asking for a friend. Let's say that you have this policy in place where people are supposed to write down their IP, et cetera. And, the employee comes in and they blithely sign everything. They don't write anything down. And then they realize that's something they already created in their own personal life, et cetera. They would like to implement sort of briefly at the company, but they still want to own it later because they didn't really produce it when they were at the company. Is it reasonable to retroactively sign a new document where those things are written down, or how would you recommend to my friend that they handle this situation?
So I'm going to first be reaching out to Nathaniel, an IP attorney, to talk that through before I make any recommendations. But I think that the company would have a good basis to say, no, if you want to introduce it and you do introduce it, then this is our property. If the employee comes to you before they introduce it, then I think there's a potential negotiation there. If they truly can prove that they kind of created this IP before they became an employee, they didn't use any of the employer's resources or time to create this IP, they probably have a legitimate argument to say, this should be protected, this should be my property. If we introduce it, I want a cut of it, or I'm not going to sign over all of my rights, and you negotiate that. But that is truly going to be a negotiation. If it's not a negotiation and the employee just after the fact tells you that, oh yeah, I developed this and now I'm introducing it, or I've already introduced it and now I want to claim rights, that's likely going to be the subject of litigation. And you're going to be in probably federal court for many years litigating that and who has the right to it and who potentially is entitled to damages. It's much better to address it in the forefront and make sure employees are disclosing that, and you're giving them the opportunity to disclose that. Because sometimes if you just have your provision in your handbook, there's not an opportunity for employees to truly disclose that. If in cases where I'm drafting a separate policy, I will have an attachment to the policy, and it's a form that employees can fill out. So it's very easy and very clear for employees to know that they're supposed to identify stuff, and that they can't just say, well, there was nowhere for me to identify it, so that's why I didn't say it. I would have if somebody had told me where to put it. So having that form can be key when you're bringing in the type of employee who may have their own IP. Your HR professional probably isn't going to have their own IP, so it may not be as valuable for them. Taking a couple steps back in relation to that, you also need to evaluate the type of employee you're hiring to determine to what extent do you need to go through to protect IP and confidential information, because there may be some employees who, one, don't have access to your confidential information just based on the nature of their job. So it may not be as important to retroactively kind of enforce this policy or put it in place, specifically in relation to the IP. Some employees are not creating IP, and so it may not be as important to ensure that they have those documents. Then that's no means saying that you shouldn't enforce these policies and have all employees sign them. But if you're in the case where you realize you're 5 years in and you haven't done any of this, it may be on a case-by-case basis trying to decide who is the most important, who do we need to address right now to make sure that our IP and confidential information is protected to the greatest extent possible.
You mentioned the retroactive piece, and I know this varies from state to state, but is ongoing employment enough in some states to ask for someone to sign one of these retroactive agreements, or do you need to offer something as part of it? Or is that just, you have to look at every single state to figure that out?
I would say definitely look at the states that you're in to determine that. But it also kind of depends on what you're asking of employees. If it's simply just to keep your information confidential, you probably don't need any additional consideration for that. If you're asking them to give up something in return, like giving up IP rights that they would have otherwise had, then you may need additional consideration for that. And continuing employment may or may not be sufficient for that.
Let's say that, your bigger company and you are giving disclosures into your patent review board, for instance, and not everything passes, right? Not everything is patentable. And some things the review board decides, this would be a good trade secret. Let's keep this a trade secret. I know opinions differ, so I'm interested in your thoughts. How useful or potentially detrimental is it to have an official place where those things that have been decided to be a trade secret are written down and kept and locked up?
So I think it is important, if you want to keep that information confidential, it needs to be in a location that is protected. And that is something to consider in all of this. And if something is ever litigated, the court is going to look at, what did you do to protect your confidential information? And if you didn't take steps to protect it, you didn't put it in a locked cabinet, you had it saved on the general internet so any employee could locate it, those are going to be factors that are going to weigh against you for that this truly isn't confidential information. You let anybody in the company have access to it. So why should we now protect it and give you damages for it being released? So I would say that should be kept in a confidential location with only employees who need access to it having access to it.
So I think the concern that I've heard other people say is, if you have a locked cabinet and some things are in the locked cabinet, and then you want to enforce something that didn't make it into the locked cabinet, are you worse off having had a locked cabinet at all? Would it have been better if you had a more general, well, we keep it somewhere and not everyone has access, but we don't have a nice, pretty list that we can look at to say some things are on it and some things aren't?
So I understand that fear. I do. But I think there are some things that you absolutely need to keep in a locked cabinet and should not be floating around the office that anyone could have access to. So yes, there are going to be some things that are on the cusp that you're trying to argue are confidential, but they're going to say, well, it wasn't in that locked cabinet. If you kind of have clear policies in place of what is in that locked cabinet, and it may be designated for certain things, and this may not fall within that, but it still is considered confidential, that argument is valid in some sense. But I think as long as you have specific policies and procedures in place of what should be in that cabinet, and if there's only certain things that go in that locked cabinet and this doesn't fall within that category, then there is your saving grace and your explanation for why it wasn't in that locked cabinet. It still is confidential, and you still took other measures to protect the confidentiality of it. But if you're leaving it in the break room on the kitchen counter, that argument's gone. And you did that to yourself.
Thank you. That makes a lot of sense. I like this idea that if you have policies for the locked cabinet, it doesn't mean that everything else that's not in there is detrimental, I guess. It's okay to keep some things super locked down and other things somewhat locked down. And maybe the idea that you have a robust policy for keeping some things locked down could potentially help you rather than hurt you in these things that are sort of in the gray area and don't quite make it in. So thank you. I hadn't heard that argument before, but I might be more convinced to. Of course, Pure already has a locked cabinet, but maybe other people will be more convinced. Yeah.
You have to think about it practically. Not everything can go in a locked cabinet at all times, but there are some things that should be in a locked cabinet at all times. And I think a court will weigh that when considering the nature of the document itself.
Okay, Luisa, so what about for bigger companies? So companies where they have a policy, they have this thing in place where people write down their IP when they join, and they even have the locked cabinet with their trade secrets. What are the next steps that a bigger company should keep in mind when they're trying to really have a robust program in place?
I think probably the reminding employees of their policy, which we did talk about earlier, doing kind of refreshers, and then also making sure you're taking steps so that if an employee does leave the company, your IP is protected. So what access do you have to the IP that is stored electronically? Do employees have laptops? Is IP potentially on employees' cell phones? Do you have access to that on their cell phone or on their computer? If an employee leaves the company, can you terminate access to any of that information on their computer remotely if the laptop is not in the office at the time of the termination? Can you wipe things from their cell phone? Again, in the same way, as soon as somebody's terminated, can you clear company installed apps on their cell phone without their permission? And that's lawful to do as long as you go through the right procedure when you're initially assigning employees those apps and putting them on their devices and locking somebody out of the computer if it truly is a company issued computer. So taking those next steps to ensure that if somebody leaves the company or you have an issue, you can retain that information and get it back. When an employee leaves the company, it may also be a good idea to have them sign a document saying that they have returned all confidential information and company information to the employer upon termination of employment. If you ever get in a dispute later on down the road of an employee then using your confidential information, you then have this document saying they returned it. And maybe they did, maybe they didn't. And that could be Exhibit A in litigation, potentially, depending on the relevance of it. So I think that's really the next step for companies who are a little more sophisticated. You have the policies and procedures in place. Now, how are you actually going to enforce them and protect your IP?
Well, Luisa, thank you for both putting fear into our listeners if they are not already thinking about these policies, and then making other listeners think about how to improve their existing policies on this episode. Appreciate your experience and thoughts on how best to protect intellectual property, especially if you're a growing company or if you're looking at potentially upgrading your existing documentation around this area of law. Thanks for joining today.
Thank you very much for having me. It's been my pleasure.
It was great to get to know you. Thank you so much, Luisa.
You're very welcome.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.